Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with. And it's also an opportunity for the court to let you know what your options are in your case and the rights that you have. Now, this is a criminal case, okay? The case that you have is a criminal case. This is a criminal court. Now, we handle what is called misdemeanor cases. Criminal cases are divided into felonies of misdemeanors. And now your misdemeanor cases are normally referred to as your petty offenses. Whereas your felony cases are normally referred to as your more serious type offenses. Now, when I use the term petty offense, does not mean that they're not serious, the misdemeanor cases. It means that they're not as serious as a felony case. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is a minimum 5 years to a maximum of 99 years of life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment, if a person is convicted, minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, the offense that you have in this case is a misdemeanor offense. So you won't have to worry about those type of punishment. Misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that start or originate in the Justice of the Peace Court or in the city court, the municipal court. They come to this court when a person is convicted in the JP court or the city court, and they file an appeal. In essence, they want to have a new trial. They get a new trial when the case comes to this court. And so, but the punishment range stays the same. And the punishment range for a Class C misdemeanor is a fine only. You cannot be given jail time, and the fine cannot be above or cannot exceed $500 for a Class C misdemeanor. Now, if the person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capious pro fine. Capious pro fine just simply means that it is a warrant for the person's arrest for them to either pay the fine or sit the fine out in jail. Now, if they sit the fine out in jail, they will be, for every 1 day that they sit in jail on this case, they'll be credited at $100 per day. All right. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is minimum 0 days to 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. We normally refer to it as deferred probation. With that type of probation, you will not have a conviction on your record. And if you successfully complete the probation, you will not have a conviction on your record, and your case will be dismissed, and you may qualify for what is called a non-disclosure. A non-disclosure basically means that your record will be sealed to the general public. And so if the general public try to have access to the record that you receive, or to the case that you receive deferred probation, and you had a non-disclosure, they cannot have access to it. Now, the operative word is the general public. Most of the public is the general public. However, there are certain governmental agencies that are listed in the Texas Code of Criminal Procedure that can have access to the case, even if you received a non-disclosure. But most of the public is the general public, and so they cannot have access to it. Now, the next type of probation is called adjudicated probation. You have unadjudicated probation, and this type of probation is called adjudicated probation. With the adjudicated probation, we refer to it as regular probation. With that type of probation, it does result in a conviction on your record. However, there's something that is called judicial clemency. And with judicial clemency, the court or the judge can set your conviction aside. And once your conviction is set aside, you will no longer have a conviction. Now, if you get a subsequent conviction or another conviction later on, then the case that you received judicial clemency on can be resurrected, revived, and it can be brought back up, and it can be used against you. Now, if you have a not a non-disclosure, but you can receive judicial clemency, and if you try to get a license with CPS, and if the case was brought back up, then they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Okay, now, everyone here who have a case, you should have a clipboard. And on that clipboard, there's some paperwork. I'm going to go over this paperwork with you. The first document, not the little not the short document, but the first full page document should be titled Judge's Explanation of Rights to Defendants Without Attorney. The document looks like this, okay? I'm going to go over this document with you, and I will constantly refer back to this document. Now, the document, it states in the first sentence that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request or ask that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, you may waive or give up your right to have an attorney. And number 3 states you may represent yourself. Now, the first sentence below number 3 states that if you want an attorney and you can afford to have an attorney, your case will be reset. Reset means that you will be given another court date. Okay? Different from the day's date. You'll be given another court date to give you time to hire an attorney. All right? And number 2, the next paragraph below number 3 states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on the clipboard. It is titled Jefferson County Affidavit of Indigence, or it may just be titled Affidavit of Indigence. And the document looks like this. Okay? This document looks like this. And what you would have to do is, for those of you who would like, now this is only for people who would like to apply for a court-appointed attorney. All right? You would have to fill out the entire first page of this document. And then you'll go to the second page. And on the second page, it states defendant's oath. You would have to fill out the top portion that states defendant's oath. And in the middle portion down here, it says unsworn declaration by defendant. You'll fill that out and then you'll stop. Now, this is only for people who will be applying for a court-appointed attorney. Now, referring back to the first document, the third sentence below number 3 states that you may not talk to the prosecutor unless you first sign a written waiver of your right to have an attorney. Now, this paragraph is for people who will be waiving their right to an attorney or giving up their right to have an attorney, and they will be representing themselves. Now, just like an attorney can talk to the prosecutors, we have 2 of them here, the assistant criminal district attorneys that work for the Jefferson County District Attorney's Office. Just like the lawyer will have a right to talk to the prosecutors, if you represent yourself, you will also have a right to talk to the prosecutors. Why? Because you'll be acting as your own attorney. And so when I say talk to the prosecutors, what I'm talking about is to see if you can work out something on your case or talk to them about your case. But in order to do that, you must first fill out you must first fill out a waiver of counsel. Now, the waiver of counsel, now this is only for people who will be representing themselves. The waiver of counsel is another document on the clipboard and is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And you will have to read this document and then you'll sign on the line that's titled defendant and the day's date. Now, this is only for people who will be representing themselves. If you're not representing yourself, you don't have to worry about this form. Now, for those individuals who will be representing themselves, going back to this first document, there's a paragraph here in block form. And the paragraph states that you may not talk to the prosecutors. Well, the paragraph states that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, this last sentence states that if you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you had decided to represent yourself, and let's say you wanted to talk to the prosecutors to see if you can get, say, probation, either unadjudicated probation or adjudicated probation. You talk to the prosecutors. Prosecutors say, no, I'm not going to offer you probation. I'm going to offer you a fine, or I'm going to offer you jail time. And you say, well, I don't want that. You tell the judge, well, Judge, I would like to apply for a court-appointed attorney. In essence, you can change your mind. Okay? Now, at the bottom of this document, in bold letters, it states defendant's choice. Mark initials next to only one choice, and there are 5 choices you can make. You can make only one of these 5 choices. If you would like to hire your own attorney, then you'll place your initials on the first line to the left, and the name of the attorney, and then you'll sign this document where it says defendant at the bottom. You place the day's date, and then you'll stop. And this is the only form you have to sign. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left, and the name of the attorney on the line to the right. Then you will sign the bottom where it says defendant and place the day's date, and then you'll stop. And this is the only form that you would have to sign. Now, if you'd like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left, sign where it says defendant, and dated today's date. And then you would have to fill out the document that is titled affidavit of interest, so we can get your financial information to know whether or not you qualify for court-appointed attorney. And then on the second page, you'll sign where it says defendant's oath, and in the middle portion where it says unsworn declaration by defendant, and then you'll stop. Now, referring back to this document, if you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left, and the name of the attorney to the right, sign where it says defendant, and then dated today's date. And then you'll stop. This is the only document you would have to sign. Now, the last statement, if you would like to waive your right to an attorney or give up your right to have an attorney and represent yourself, then you'll place your initials on the fifth line to the left. You'll sign this document where it says defendant, and then you'll date it today's date. And then you will fill out the document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You will sign it and then date it. This is only for people who will be waiving their right to have an attorney. Okay. We have any questions? Yes.
Let's say you go with a court-appointed attorney, and then you see there's inadequate representation of what you need provided.
You can talk to your, if you have an attorney, you can talk to your attorney about that.
Is there?
But he'll tell you there's a process.
Okay.
Right. Okay. Okay. Anybody else? Okay. All right. Now, you have a option to enter a plea of either guilty or either not guilty, guilty, or no contest. If you enter a plea of not guilty, you're telling the court that you did not commit the charges, that you have not committed the offense that you have been charged with. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. If you enter a plea of no contest, then you're telling the court that you will not be fighting or you will not be contesting those charges. Now, you have a right to have a trial by jury. When those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors. They will listen to all of the evidence that's presented by the state, by the defense. They will listen to the arguments of the state and the defense, and then they will go back into our jury room and deliberate, and they can either find you not guilty or guilty. You also have a right to waive your right to have a jury trial. That means you have a right to give up your right to have a jury trial. Now, if you waive your right to have a jury trial, if you give up your right to have a jury trial, you would not be having a jury trial. If you still want to have a trial, you would have what we call a bench trial. It is a trial without a jury. It's a trial before the judge, who will be the judge and the jury in the case. The reason why they call it a bench trial is because the judge sits on the bench. Now, the judge will listen to all the evidence that's presented by the state and by the defense. The judge will listen to the arguments of the state and the defense. The judge will apply the facts to the law, and then the judge will decide whether to find you either not guilty or guilty. Now, if you decided not to have a trial and you wanted to enter and you entered a plea of either guilty or no contest, either you, or if you represent yourself or your attorney, talk to the prosecutor, and once you negotiate with the prosecutor, you accepted their offer, then you could come before the court on what is called an agreed plea bargain. A plea bargain is nothing more, it's simply just an agreement to settle your case. You came to an agreement to settle your case, and you accepted the offer that they made. So, for example, let's say the state offered unadjudicated probation, and you accepted that. Okay? That's an agreed plea bargain. That's an agreement between you and the state. That agreement has to go before the judge. Okay? And the judge can do one of two things. The judge can either accept or reject the agreement, the plea bargain agreement. If the judge accepts the agreement, then if you decide within 30 days that, you know what, I think I've been wrongfully convicted, or the court committed an error by convicting me, then at that point, if you decide you want to appeal, you have to get permission from the judge who followed the plea bargain agreement. And if the judge gives you permission, the case will leave this court, go right upstairs to the 9th Court of Appeals, where there are 4 justices up there, and they will review the case. They can do one of two things. They can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court, the 9th Court of Appeals. Actually, you can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, which is located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. And with the pro se petition for discretionary review, what that just simply means is that pro se means yourself. You're representing, you don't have an attorney. And you'll be petitioning the Texas Court of Criminal Appeals to review your case to see, one, whether or not your appeal should have been granted by the Ninth Court of Appeals, or whether or not this court committed an error by convicting, or whether or not you was wrongly convicted. They can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty. Case is over. Or they can send the case to the Ninth Court of Appeals with orders, or they can send it back down to this court with the orders. Or the next option is if they deny your petition, then at that point, your conviction will stand. Now, getting back to plea bargain, we talked about how you can have an agreed plea bargain. You also can have what is called an unagreed plea bargain. And what an unagreed plea bargain is, it means that you talk to, if you represent yourself, you talk to the prosecutors, or if you have a lawyer, your lawyer talk to the prosecutors, and you're rejecting the offer. Okay? You don't want the offer, but you want to still enter a plea of guilty in no contest. And so if that's the case, then your case would go before the judge on an unagreed plea bargain. And the judge can assess punishment anywhere within the punishment range. Class A, or Class B, or Class C misdemeanor. All right. Now, the next right I need to talk about is your right to have witnesses to come to court. Witnesses sit in that chair right there that we call the witness stand. And basically, what a witness can do, they can testify for you or against you. You also have a right to, ask them questions, or your lawyer have a right to ask them questions if you're represented by the lawyer. We call that either direct examination or cross-examination. You also have a Fifth Amendment right against self-incrimination. What that means is, in the United States Constitution, it gives all of us rights. One of the rights is a Fifth Amendment right to remain silent. Okay? What that means is this. The state, the government, the DA's office, they cannot force you to testify against your will if you exercise or invoke your Fifth Amendment right against self-incrimination. Now, I know a lot of us watch television shows, and one of the shows that, you see a lot of shows involved in like Law and Order. You might see the television lawyer walk up to the witness stand and ask the witness a question, and then the witness say, "I take the fifth." And what the witness is actually saying is, I'm exercising my Fifth Amendment right against self-incrimination. I'm not saying that. And if you think about it, it makes sense. And the reason why it makes sense is because the state has the burden of proof. That is, they have to prove that you are guilty of whatever you charged with beyond a reasonable doubt. Okay? You don't have to prove yourself guilty. Okay? It's their job. So that's why you can exercise your Fifth Amendment right against self-incrimination. Now, you can waive it, which means that if you waive or give up the Fifth Amendment right against self-incrimination, that simply means that you will be testifying. Now, the other right I like to talk about is your right to have what is called discovery. And what discovery is the right to have access to the state's file. It's the right to have access to the evidence that the state will be using against you. You have a right to see your statement, witness statements, police reports, lab reports. You have a right to see photos, listen to audio recordings. You have a right to see videos. You also have a right to see have any access to any documents or instruments that the state may have. Now, you can waive or give up your right to discovery as well. Okay. Now, everyone that's here for a case, you are here because charges have been filed against you, been arrested, placed in the Jefferson County Jail, and you bonded out of jail, and you're out of jail on either a cash bond, which means you pay the full amount of the bond to get out of jail. Get out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail. Or you're out of jail on what is called a PR bond or a personal recognizance bond, which means that you do not have to pay any money to get out of jail. You were released under your own personal recognizance. Okay. Now, I say that to say this. Every day that you spent in jail can be used as credit towards your punishment. Every day that you spent in jail can be used as credit towards your punishment. Now, the operative word is day. Okay? For example, let's say you were booked into jail at 11:59 p.m. last night. And let's say you bonded out of jail at 12:01 a.m. this morning, 2 minutes later. Okay? That's 2 days credit. And the reason why it's 2 days credit, because it's 2 different days. Okay? It's 2 minutes, but it's 2 different days. So you get 2 days credit. Okay. So let's say you and the state come to an agreement that you serve 5 days in jail. The state offers you to serve 5 days in jail, but you've already served 5 days in jail. You know what that means? You won't have to serve any more time in jail because you'll be given credit for the time that you've already served. And you'll be given what we call credit for time served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that means you would only have to serve 2 days in jail. Why? Because we'll subtract 5 from the 7, and that leaves 2. Now, everything that you spent in jail also can be used as credit towards your fine and court costs. So, for example, you spent 5 days in jail, that's $500 that will go toward your fine and court costs. If the state is offering you a fine and court cost of $500, that simply means you won't have to pay nothing because the time that you spent in jail has already paid it off. Therefore, you wouldn't have to pay anything, so you'll be given what we call your fine will be taxed and retired. Now, if the state is offering fine and court costs of $700, that means you would have to pay $200. Why? We would subtract 500 from the 700, and that leaves 200. Now, you'll be required to pay the balance on the day that you take care of the case. Now, if you can't pay it on that day that you take care of the case, no problem, because the court can put you on what is called a payment plan, and you can pay it off in small monthly installments. Now, if you cannot pay it off, even if we put you on a payment plan, then the court can convert the fine, the balance that is, to community service. And you'll be required to do work your time off at a nonprofit organization in our community. Now, for every 1 hour that you work, you'll be credited $12.50 that will go toward the fine and court costs. So if you work 8 hours one day, that's $100. So if you work 2 8-hour days, that's $200, and then your fine and court costs is paid off. All right. Now, Jefferson County has a program that is called pretrial diversion. When I say Jefferson County, I'm talking about the district attorney's office. This program is for people who haven't been in trouble before. First time getting in trouble with the law, then they will dismiss your case. And you can get it expunged from your record. Expunged means wiped off, deleted, or erased, like it never happened. Now, in order to qualify, it has to be a case. It cannot be a case involving unlawful carrying of a weapon or resisting arrest. And then 2, you have to have an attorney to assist you to get it with the application process to get into the program. The attorney could be a court-appointed attorney. You don't just have to hire one if you can't afford to hire one. And as I mentioned to you earlier, this has to be your first time getting into trouble. All right. And if you qualify, you've been into the program, They'll dismiss the case. And once you complete the program, you can get an expunction, which means you can get it erased, deleted, or wiped off your record like it never happened. All right. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. It's for veterans only. And with that program, only thing you have to do to get in that program is be a veteran. Whether you had an honorable or dishonorable discharge, just a veteran. Get into the program, complete the program, they dismiss the case, and after the case is dismissed, you can get what is called a non-disclosure, where your record is sealed to the general public, as I mentioned to you earlier. Now, this court, County Court of Number 2, Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office, which was March. The program started in March of 2017. The program is the CSI program. It's an acronym, CSI, that stands for Community Safety Initiative. It is a program that is designed to address the issue of recidivism. Recidivism means that people continue to commit crime. And how do we prevent that? Well, we prevent it through the Community Safety Initiative. With that program, we have partnerships with various agencies. And one of the agencies that we have a partnership with is Spindletop Center. And we have some representatives from Spindletop Center who's here. They're going to come to you in a few minutes and tell you a little bit more about the program that Spindletop has to offer. Now, Spindletop is our local mental health center in the Southeast Texas region. And basically what Spindletop do, Spindletop has expertise to address any mental health needs that you have. For example, you don't have to be incompetent or insane. You can merely suffer from depression or anxiety, or you have a host of mental illnesses, and they have the expertise to address those issues that you may have. But basically what Spindletop will do, they will conduct a private interview. They can do it either in our jury room, at their facility, or by telephone, or whichever is convenient for you. They have the ability to do, they will conduct an assessment. An assessment is to determine what your mental health issue is. They will diagnose what that issue is. And then they can develop a treatment plan for either outpatient or inpatient treatment. Spindletop also has a program that is called ATAR. It's an acronym, ATAR, that stands for Addiction, Treatment, and Recovery. And we also have a partnership with our local Drug and Alcohol Council that has a program that is called OZAR, which is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Funding. Both of those programs are drug and alcohol recovery programs. And in those programs, what they will do is they can conduct the screening. They can do an assessment to determine what your alcohol and drug issues may be. And they can develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry and the shipping industry and the chemical industry. Once you're trained in any one of those areas, they will help you to get a job that you're trained in. Now, if you have not graduated from high school, or if you do not have a GED, CIC also has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time. We take our time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you go to county court at law number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes in the community. So if you're interested in any one of these programs, just let us know, and we can get you the brochures and get you in contact with people that you need to talk to get on the road to living your best life. So as I mentioned to you earlier, we have some folks from Spindletop. They're going to come right now. We have Miss Odalis, we have Miss Tanya, and we have our mental health deputy, DeVere. Pop.
I know we look a lot. I'm Dr. Powell. About 9 years ago, we started teaming up with our local medical professionals. At work, all right, down front, so we developed a problem. Maybe have, I'm having a piece of paper. Tanya, she's gonna go over some of those parts that going top pass, and it's not painful for you to like fill out. I don't know about. Should I answer any questions that you have? It would be not being that.
Good morning. As Deputy Paul said, I'm Tanya with Spindletop. And we have some services available for you guys. Judge Holmes also said things about employment, health. With us, it's either mental health or it could be physical. If you guys need services at Spindletop, we do have mental. We have substance abuse. We also have options for assistance with clothing, with transportation. We have assistance with doctor's appointments, Deputy Paul and myself. We also have 2 qualified mental professionals. They are available for pickup. They have a doctor's appointment with Spindletop. You guys can come and pick you guys up for transportation, and we'll be able to meet with you with the doctor. This is totally optional. We don't have to come into the doctor with you, but if you would like services, we can assist. As I said, with mental health, we also mental disability. If you guys need assistance, this form here, as Deputy Paul said, it's totally optional. You can fill out this form. We can speak with you guys today here in the court. We can also do telephone or text message or email. It's at your option. If you guys are not looking for services, you don't have to fill out this form. Deputy Paul and Ms. Lavales will provide it up for you guys. Or if you would like to, because just your option. Alright, and the question is. If you guys are interested in services, don't fill it out for you guys. If you do decide to speak with us in person, just know that it's confidential. Or whatever we need to speak about, we're basically.
I had a question for the judge about the fifth amendment input point, about the invocation of the right, people. Is it a start, that goes my question.
Yeah, Judge, I'll be able to address it. Email. So you. We have one other question, Judge Holmes, but I explained to him that ask when it comes to the bench.
Okay.
Just come speak with you. I'm gonna be with them, dressing all gear, so I think I'm there, because that's not what I do. All right. don't know how to do it.
Yeah, I'll go over that.
So up there.
Okay, all right, thank you, for Dallas, Tanya, and, Deputy Cobb. Sir, what you say? Yeah, you can, go out, that door is locked, you have to go out this door. Okay, now, ladies and gentlemen, the paperwork that you have, if you need assistance with filling out the paperwork, we have our court personnel, including myself, who will be happy and, and able to help you with filling out the paperwork properly. Now, once that paperwork is filled out, we're gonna pick it up from you. And then we're gonna call you up before the bench, and we're gonna put you into one of three categories. One category is you wanna hire an attorney. Now, if you wanna hire an attorney, your case will be reset today. And you'll be given another court date to give you time to hire the attorney. Number two, if you are requesting a court-appointed attorney. If you qualify for a court-appointed attorney, you will be appointed a court-appointed attorney before you leave here. Okay, this morning. And number three, the next category is if you would like to represent yourself. That means you're waiving your right to have an attorney. You want to represent yourself. Then you'll have an opportunity to talk to one of the two prosecutors to see if you can work out a plea bargain agreement. And if you work out a plea bargain agreement, that case will be taken care of this morning. Okay? Now, it's going to take us a few minutes to pick up the paperwork from you. If you need to use the restroom, there are two restrooms right out in the hall. We have the mid restroom that is in front of County Court at law number 3, which is right next door. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. You'll be allowed to use the restrooms. Now, please do not leave the courthouse. If you leave the courthouse, get to your case, you're not here, your bond can be forfeited, and if your bond is forfeited, a warrant will be issued for your arrest. You'll be arrested and placed in the Johnson County Jail. And guess what? We have to go through this all over again. And so we don't want to do that. We want to try to get you in and out as soon as possible. Okay? Now, do we have any questions before we go into recess?
I had a question about success rate with a court-appointed attorney versus.
Well, I can't discuss that with you about success rate. This is a range, okay? You can either talk to an attorney or you can look that up yourself, okay? Right now, this is an range, okay? And I told you from the beginning, from the onset, telling you what your rights are, what your options are concerning your case, and we already did that. And so this is an arrangement. So I'm not here to give anybody any legal advice. Because what? I'm the judge. I'm not your lawyer. If you hire a lawyer, you can ask that person. If you appoint an attorney, you can ask that person. Okay? Now, if you represent yourself, you're acting as your own lawyer. Okay? And so the judge cannot give any legal advice. Okay? The judge is kind of like we just neutral and detached, not on nobody's side, not on the state side or the defender's side. We cannot advise anything. Yes.
What about the code number? I don't even.
Oh, don't worry about that. Well, the only thing you have to do, you know what? You asked a good question. Okay? On that paperwork at the top, it states state of Texas versus, and there's a line that says blank.
Right.
Make sure you print your name in. And the reason why I'm saying print is because we can't read people read it, they write in cursive. You can't read it. In fact, I was told in college that I had to print. Because if I continued as bad as my handwriting was, I was gonna flunk out. Okay, so make sure that you print your name on that line. Yeah. Print your full name on that line, okay? So that when we look at your paperwork, we'll know who it is. Now, when it says defender, you're gonna put your signature where it says defender, okay? That's your signature go where it says defender at the bottom of any of the paperwork, okay? So at this time, be mindful that we're gonna be in recess, but we're still in session. And which what I mean by that is you're still in the courtroom. So conduct yourself accordingly. Okay? Yes.
We needed a call to ask questions, so see about the attorney situation, could step out and make a call.
You can do that. Yeah, you can do that. Okay. Okay. Any other questions? Yes, that's everybody gotta fill it out. Yeah. Yeah, so whether it's your first and that, now if you've been here before on this same case and you filled out that paperwork, you don't have to fill it out. Yes,
Okay, say I wanna I wanna find out whether I wanna have say guilty and find out what to do, or do I wanna get a try by, first one turn?
okay,
Okay, I don't really know what my choice, what my, been, what I'll be charged, I mean, whatever, how much it's gonna be, I'm out on bounce. I mean, I got a PR bond where I pay a payment per month.
you don't pay nothing on the PR, but anyway, just on,
I
what you
don't
saying?
really know how much it's gonna be.
Okay, so you're
I
saying
don't know how much
that,
it's gonna be, you didn't do it,
let me ask, okay, so basically what you're saying is, let's say you worked out an agreement with the state.
Right.
And they tell you, for example, let's say they offer you a fine in court cost, and then you can't pay it now, but you'll be put on payment plan.
I'm talking about,
Okay, what we would do is, we'll talk to you. First of all, we'll see whether or not you can pay it.
Right.
That's the first thing.
that,
If you can't pay it, then the court has some other options. Okay, for example, we can go to Texas Code of Criminal Procedure, there's some other options we can go through. I think I mentioned one was like, community service. I already mentioned that, that's enough, that's an option.
Yeah, I've got the same plan with what I was already.
Okay.
That was mine.
Okay, well, I mean, just, fill out the paperwork. And now if you plan on representing yourself and talking to, one of the prosecutors, once the case comes before the court, then the court will go over it, and then the court is gonna ask you whether or not you can pay it. And if you can or cannot, that's not gonna change the agreement that you made with the state. There's some other things that we can do.
Yeah.
Okay?
Trying to see if I can put that payment plan.
Okay, that's what,
Online.
okay, that's good.
Can I get counsel with one of these guys?
But you gotta fill out the paperwork first. Now, what you're saying is you would like to represent yourself.
No, I'm just saying, I don't know if I wanna get a court appointed or work out deal with them, so how do I know?
Well, I
Can't,
mean, okay, I can't tell you what to do. I can't tell you what choice to make.
be better off just get a court appointed attorney.
If that's what you wanna do, that's fine. If you qualify, yeah, that's fine. I can't give you any advice
I understand,
as to what you need to do.
good.
Okay, anybody else? You had something? Okay, yeah, but we can, I think I went over the veterans program. That's, if, the veterans program is just, that's an option. That he can take, accept or reject. He doesn't have to, and that's just an option. I just, was basically letting you know all of the programs, the various programs that the county had available. But it's your choice as to whether or not you want to participate in any of those programs. Okay? It's not no mandatory thing. Okay? All right, the court is gonna be in recess.
We can step out.
Yeah, but make sure you come back in, because as I mentioned to you earlier, once, if you're not here when your case is called, your bond could be forfeited.
I was saying, we step out.
Mr. Blanchard? You can take your mic off of mute.
Yes, sir.
Your case, we can reset your case to, what was the date?
February 10th.
February the 10th. Okay?
Okay.
So on that date, you need to be in court in person at 9 a.m. County Court at Law Number 2, Jefferson County, Texas, and Beaumont, Texas.
Okay. And that's February 10th at 9 a.m.
Yes, February 10th at 9 a.m. We're located on the second floor in the Jefferson County Courthouse.
Yes, sir.
Okay?
I just have,
And notice will be sent to your bondsman.
okay.
All right. Stay in
I-
contact with your bondsman. You're free to go and you have a blessed day.
Okay. I have one question. You
Okay.
may not be able to answer it. I did a treatment program back in August. When I go on February 10th, should I bring that paperwork with me?
Yeah, you can bring it with you. That's fine.
I don't know if it's gonna, I just want to have it.
Yeah,
just
you could
proof
just,
that
yeah,
I've done it.
you could have it with you. That's fine.
Okay.
All right.
All right.
All
Thank
right.
you.
We'll talk to you later. You have a blessed day.
You too, sir.
Okay. Mr. Moore, would you please raise your right hand? Mr. Moore, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Moore, you may put your hand down. How are you doing, Mr. Moore? I'm doing fine, thanks for asking. Now, Mr. Moore, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to hire your own attorney? Before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Moore, your case will be reset by our court coordinator to give you time to hire your attorney. Once you get your reset from the court coordinator, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Tina Bobineau? Ms. Bobineau, your full name is Katina Bob. Ms. Bobineau, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Bobineau, you may put your hand down. How are you doing, Ms. Bobineau? I'm doing fine, thanks for asking. Ms. Bobineau, I have a document before me that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
yes, sir.
And are these your initials on the line that state you'd like to hire your own attorney? Ms. Bobineau, before you signed and initialed this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay. Ms. Bobineau, I read your answers. Your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to give you your reset. Once you get your reset, you're free to go. You have a blessed day. Please have a seat in that second chair on the wall. Mr. Howard, your full name is Jacqueline Deshawn Howard. Mr. Howard, would you please raise your right hand? Mr. Howard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Howard, you may put your hand down. How are you doing, Mr. Howard? I'm doing fine, thanks for asking. Now, Mr. Howard, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant? And are these your initials near the line that is checked that states you like to apply for your apply for a court-appointed attorney? On the next document, this document is titled Jefferson County Affidavit of Indigence. Mr. Howard, do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant. Is this your signature? Mr. Howard, before you sign and initial these documents, did you read the documents? Did you read the documents before you signed? And did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Howard, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Mr. Howard, do you see that title? And I'm going to go over this document with you. Mr. Howard, it states, following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the drugs and alcohol in the defendant's body. Do you understand that condition? And Mr. Howard, condition 3 and 4 does not apply. However, condition number 5 on the next page does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Howard, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes.
Okay. Mr. Howard may have a seat in that first chair. Wait for your name to be called. Once your name is called, go to the window. Once you finish at the window, you're free to go and you have a blessed day. Latravian Coleman Jr. Okay, Coleman. Okay. Mr. Coleman, your full name is Latravian Coleman Jr.?
Yes, sir.
Mr. Coleman, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Coleman, you may put your hand down. How are you doing, Mr. Coleman? I'm doing fine, thanks for asking. Mr. Coleman, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize? Titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Coleman, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Coleman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over this document with you, okay? It states, following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. You understand that condition?
Yeah.
And condition number 3 and 4, they do not apply. However, condition number 5 does apply, and condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now, Mr. Coleman, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, warrant will be issued for your arrest, you'll be arrested and placed in Jefferson County Jail. Do you understand? Okay, now, Mr. Coleman, our court coordinator is gonna reset your case. Once your case is reset, you'll be free to go, and you have a blessed day. Please have a seat in that second chair on the wall.
Oh.
Mark Crocker. Mr. Crocker, your full name is Mark Andrew Crocker?
Yes, sir.
Mr. Crocker, would you please raise your right hand? Mr. Crocker, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Mr. Crocker, you may put your hand down. How are you doing, Mr. Crocker?
Pretty good, you?
I'm doing fine, thanks for asking. Mr. Crocker, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you like to apply for court-appointed attorney? Next document is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature on the line that is titled defendant. Is this your signature?
Yes, Your Honor.
Now, Mr. Crocker, before you signed and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Mr. Crocker, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. The court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day.
Yes, Your Honor, sir.
Okay, please have a seat in that first chair on the wall. Wesley LeBlue. Mr. LeBlue, your full name is Wesley J. LeBlue?
Yeah.
Mr. LeBlue, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. LeBlue, you may put your hand down. How are you doing, Mr. LeBlue?
Could be always be better.
Okay, could be worse too.
Nah, we ain't getting worse.
Now, Mr. LeBlue, I have before me a document. I have 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant? Are these your initials on the line that's stating you'd like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled defendant signature. Is this your signature? Mr. LeBlanc, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. LeBlanc, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. Could you step to the left of the bench and take these bond conditions that I'm going to go over with you? Okay, you can stand back in front of the bench. Now, Mr. LeBlanc, that document is titled Standard Bond Conditions and County Court at Law Number 2. Do you see that title?
Yeah.
Okay, it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, and B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Let me see.
The victim, we use the initials, it would be,
Okay.
50 KL.
Okay. Okay.
What I had it.
Hold on a minute, sir. Okay,
I had a question, with the contact measure between my son, he's tried to reach out, but I didn't contact.
yeah, that's good.
But the thing is, I don't want him to have a abandonment complex thinking that.
Well,
He's a child and he don't understand.
Okay, well, okay.
So I'm trying to figure out.
But
what could be done.
it's not for him to understand, it's for you to understand that you cannot have any contact.
Yeah,
Okay, if somebody call you, you don't have to answer.
yeah, it's correct.
They text you, you don't have to respond.
Yeah, that's
If
correct.
they contact you by social media, you don't have to respond. Okay?
Okay.
Now, if you do you understand these conditions?
Yeah, that's what I'm trying to get a form of understanding what. I have family members that he try, cause he can't get in contact with me, he contact.
So you can't, get
And
in contact with no third party where you try to
Yeah,
there's no
that's-
contact.
and,
Okay. But
Can they explain to him what's going on, so
But-
he's not confused as a child?
Well, they-
He doesn't understand. I'm
okay,
talking about from their end, when they try to contact him, can they
well, yeah,
explain to them, cause he has no idea what's going on. But
Okay. Okay, Mr.
Thank
Yes.
you, John. The state's obvious concern, if there is indirect contact, God forbid is saying, why are you doing this to them? Dad, try to explain it any other kind of way that would be intimidating against her on the witness judge. I don't know how, once you get a hold of his attorney, he can get a hold of me and maybe we can find someone who understands that's in the middle. But until that happens, there shouldn't be any contact, Judge. But he
Understand.
can work to,
I said, I understand it like that.
Okay, but did you understand what he just said?
Yeah, you don't want no confusion involved and no contact, that's what I'm saying.
No, He basically said that when you have an attorney that has been appointed to represent you.
Okay.
Explain that to your attorney. Have your attorney to reach out to Mr. Williams. And they will discuss it, then they'll be able to work it out.
Okay.
Okay?
Yeah.
All right. Now, do you understand this condition?
Yeah.
All right. Now, condition number 4 does not apply because it only applies in a DWI case. Your case is not a DWI case. Now, condition number 5 does apply. When condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
I have a question about that. Why would my amendment right be revoked? When I
You
was
can
in-
discuss that. You can
in
discuss that.
successful?
You can discuss that with your attorney.
Okay.
Okay? All right. Now, if you violate any one of these conditions,
That's what I'm saying. You can inadvertently do stuff, you know what I'm saying? Do I have the ability to get it or allow somebody to take the firearm that's a family member so that they have possession of it so that nobody else could take it?
okay, you have an attorney. You can discuss that with your attorney.
Okay.
Okay? Any legal questions, or any questions of that nature? That's why you have an attorney. Okay, and your attorney is one who is quite competent in those matters.
Okay.
All right. So now, Mr. LeBlue, your case is going to be, did I give you his paperwork? Okay, and that goes with it. Now, your case is going to be reset, meaning that you'll be given another court date, and give you time to talk to your attorney. You're gonna have a seat in that chair, second chair, wait for your name to be called. Once your name is called, you go to the window, and once you finish at the window, you'll be free to go. You have a blessed day, and make sure you stay in contact with your attorney.
Sure.
All right, just have a seat in the first chair on the wall. Elise Rios. Did I pronounce your first name correct?
Wait about 24 hours.
Alizette?
Allison,
Okay.
and this door right here is the lock.
Now, Ms. Rios, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Rios, you may put your hand down. How are you doing, Ms. Rios?
I'm fine, how are you?
I'm doing fine, thanks for asking. Now, Ms. Rios, I have 2 documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
Or these your initials on the line that state you'd like to apply for a court-appointed attorney? Have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Hmm.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Ms. Rios, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, now, Ms. Rios, I have a question. Turn this mic on mute. The court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day.
Okay, so once I talk to my attorney, I have to reset another court date.
A court date will be, you're gonna have a court date reset now, and then your attorney is gonna talk to you. If your attorney your attorney has to, talk to you, gonna get, the discovery, the information, the evidence that the state has in their files. And then she's gonna meet with you, she's gonna investigate, and then by that time, we'll come back into court, and the attorney is gonna make an announcement as to whether or not she want a trial, or whether or not she needs more time, or whether or not they have a plea bargain agreement worked out. Okay? Get your reset. Once you get your reset, you'll be free to go, and you have a blessed day.
Yeah, I'll see what you need first.
Okay, Dorian, Cameron. Mr. Cameron, your full name is Dorian Dion Cameron.
Yes, sir.
Mr. Cameron, would you please raise your right hand? Mr. Cameron, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yeah.
Mr. Cameron, you may put your hand down. How are you doing, Mr. Cameron? I'm doing fine, thanks for asking. Mr. Cameron, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendant. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
Also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Cameron, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yeah.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Make sure that I initialed the second page on the judge's explanation on Miss Rios' case. Yeah. Did I do, no, on the affidavit of indigence.
Oh.
Did I check off? Yes. Yeah, I see it. All right. Now, Mr. Cameron. I'm looking at, let me do this here. I need to go over some information with you. Mr. Cameron, you didn't qualify for court-appointed attorney. Now you would like to have your case reset to hire your own attorney. Is that correct? Okay, your case is going to be reset. Our court coordinator is going to reset your case. Once she resets your case, you'll be free to go. Now, before she does that, I need to give you some bond conditions. There you go. Mr. Cameron. The document that you have before you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that
Yes, sir.
title? Now it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Mr. Williams, do we know who? Let me see.
Yes. Yes, Your Honor. Miss Teresa Clowers, Clowers, Teresa, Ter.
Okay, let me see.
Teressa.
Teressa, last name?
Clowers, Clowers.
Clowers, Clowers. Now, Mr. Cameron, do you understand condition number 3?
Yes, sir.
Now, condition number 4 does not apply. Condition number 4 applies only in a DWI case. Your case is not a DWI case. Condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing of firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, we have a condition number 7 here. And condition number 7 states the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. So you have to get a GPS. Do you understand that?
Yes, sir.
Okay, and she has some places that you can contact for that. And once you get it, you can either email the receipt to the court, or you could bring it up here. And if we're not in session, you could leave it with the receptionist who's on the 2nd floor, and the blue doors next to this courtroom.
Okay.
And she'll get it to us, okay?
Okay.
All right, have a seat in that first chair. Wait for your name to be called, and as I mentioned to you earlier, your attorney in this case is attorney.
You said judge.
Hmm?
You said the-
Okay, yeah, okay, that's right. He was he was denied attorney in this case. Okay. Okay. Okay, let's see. Brian, David Belvin, come on up. These are some individuals. Hampton, this is yeah,
I sent it to you.
you did?
Yes, sir. Yes, sir.
Hey, how you doing, Mr. Belvin?
How you doing? Good morning, sir.
All right. Now, Mr. Williams, Mr. Belvin and I, we're fraternity brothers. Actually, I've been knowing Mr. Belvin.
Yeah,
Uh,
my sympathy.
Is,
That's that.
okay. We'll let that statement go. Okay. Now, Mr. Belvin, Mr. Belvin and I are fraternity brothers, and as you know, as part of the judicial code of conduct.
Judge, the
The
state
court
has
is,
absolutely no,
But there's
issues
a-
with that judge.
that, I hadn't finished.
Yes, sir.
The other issue is, I know that, at one point I was campaigning for judge and Mr. Belvin worked. Basically, he helped. And
Well,
I
that is-
think,
That's fine,
that-
Judge, but
I know, but I think, if I'm not mistaken, that's an appearance of impropriety.
no,
that's-
well, if, Judge, the state has absolutely no question as to this, the character of this court and that you would be fair, Judge. We waived anything when it comes to any, appearance of impropriety. The court
Okay.
will be fair, the court will abide by the law. There is no issue with the state, Judge.
Okay, only issue is, I think that, there's, I have an issue because it's an appearance of impropriety.
Well, if you,
Yeah, that's the issue that I have. And I know that in circumstances of this nature, we normally refer, judges transfer cases, back and forth. And I don't know what, cause he is, from, Port Arthur. He is well known, his family is well known. And I don't know if, Judge, Woods I don't know.
I graduated from law school with Judge Woods. We classmates from law school.
Okay, that's well, yeah,
We
so,
graduated. law
so he
school
may have,
Together, 2003.
yeah,
So we classmates.
okay, that may be an issue. So I think,
there may be issues, look, all the way around. I'll just speak frankly, Your Honor. Well, given in the wonderful state of Texas, Judge, that we have, judiciary is elected. Once you have an elected judiciary, you will have campaigns, you will have campaign finances. Judges, it'll be the state's position. Every judge that may be elected, people will appear before him that they gave him money, they worked on the campaign. That's just the nature, Judge,
That's why-
of an elected
I
judiciary.
understand.
Having said that, Judge, everybody can't recuse themselves otherwise, by having, from elections. With that said, Judge, I see no reason, there would be an appearance of impropriety. It's the state's position of every elected official who received any money from any attorney, Judge. That just simply can't be the case. The court, the state trusts the court's, ability. I think that's just the nature of it. Nothing is extraordinary in this instance to where the court should, recuse itself.
Okay.
That's the state's position.
Yeah, but what we'd have to do, I would have to, other than abundance of caution, I'm well versed in the judicial code of conduct. And I've had issues that has come up before. And so of abundance of caution, I can I think that, the court is in a position that it has to, I think there's there's an appearance of impropriety.
Let me
Okay.
ask it like the court this then, Judge. And I'm not trying to be difficult. If he's a classmate of Judge Woods, those guys spent 3 years together, knowing each other. How would it be any greater of an appearance? Judge Woods also is from again Mid County, and by respectfully, Judge, is Mr. Belvin, family well known, worked on the campaigns. I have very little doubt that he also worked on Judge Woods' campaign.
Okay.
Judge,
But,
what
but,
can we move the
but,
case to,
no,
Your Honor?
but I'm saying, there are, things that, can be done to, actually get this case, through the through the system, okay? As well as, so at this point, the court is, at this point, the court is of opinion that it's going to, recuse itself in this instance. And so, but I need to, I don't know if Judge Woods is going to accept the transfer, because we can just normally transfer it over. And if he does, if he doesn't, then we would have to get a well, we'll deal with it if we get to that point. But right
Can
now,
we just cut out the step judge, and a judge can either the court can sui sponte, appoint, I guess, a special master, or just go ahead and.
it doesn't work like that.
Then go ahead and refer the case.
Yeah, it doesn't work like
Is
that.
the administrative judge who the case gets
Right.
referred to?
Right,
Then the case referred to the administrative judge. He
Right.
lays the exact same basis. In fact, Judge, I would submit to the court, spending 3 years with someone may be a lot closer than also working, I guess, on the campaign. We can cut off the middle
Well,
person, Judge.
I mean, okay. So at this point, the court is going to recuse itself. And so what we'll do is submit the application to the administrative judge for the appointment of a judge to a visiting judge to handle this case. Okay, but it has to go through, they may or may not grant it, so, okay. So we'll get to, I'll submit the necessary paperwork. Okay,
Yes, sir.
okay. So that's what we're gonna do at this, so at this point, we're going to, the court is going to recuse itself and submit the necessary paperwork to, the regional presiding judge. That's the process,
Yes, sir.
okay?
Yes, Your Honor.
Okay. All right. So that's what we'll do. And then let Okay. Okay, this is cause number 25 CCCR 2540 case of style of state of Texas versus LaRonda L. Hampton. Ms. Hampton, would you please raise your right hand? Ms. Hampton, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hampton, you may put your hand down. Now, Ms. Hampton, how are you doing? Okay. Now, Ms. Hampton, I have before me, well, first of all, before we get started, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. You waive or give up a court report? Okay. Now, Ms. Hampton, I also have before me, well, first of all, we have Mr. Shane Hilton. He's with the DA's office. Mr. Hilton, how are you doing?
I'm good, Your Honor.
Now, Miss Hampton, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, LaRonda L. Hampton, on or about July 6th of 2025, while you were in Jefferson County, Texas, that you was charged with the Class B misdemeanor offense of driving with license invalid or previous convictions or without financial responsibility. Ms. Hampton, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, and no contest. Now, you're pleading no contest freely and voluntarily. And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Now, Ms. Hampton, I also have before me several documents. First document on paper is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? Are these your initials on the line that's titled, that state you like to waive your right to an attorney and represent yourself? I also have a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Do you recognize this document? And is this your signature on the line that's titled Defendant? I also have a document on this tablet that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there is a signature, excuse me, there are 2 sets of initials. First set of initials is on the line next to a box that says check nolo contendere, which means no contest. Did you place your initials here? Second set of initials is next to a statement that states, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of no contest or guilty. Did you place your initials here as well? On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature? Now, Ms. Hampton, before you signed and initialed all of these documents that I just showed you, did you
I already knew what I was.
read the documents?
Yeah, yeah.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay. Ms. Hampton, are you a citizen of the United States?
State over State's Exhibit 1.
Now, the state is offering State's Exhibit Number 1 to be offered as evidence in this case. A State's Exhibit Number 1 is this first document on the tablet that I show you. This is the same document that have your initials in these 2 locations and your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's Exhibit Number 1 will be admitted. Now, Ms. Hampton, the next question I'm getting ready to ask you, I'm not trying to meddle into your own personal affairs. All right? Is there any evidence that you're currently mentally incompetent to stand trial? Okay, Ms. Hampton, I will accept your plea of no contest. I will find that you're mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 1 day bail time with credit for time served of 1 day and ask for that 1 day credit to go towards the court costs in this matter.
Okay. You got out of jail the same day?
Yeah, I think.
Okay, so, okay, I was just wondering, because if you got out of jail the next day, it would be 2 days credit. Did you see a magistrate while you were at the jail?
Oh, it's 2 days.
It had to be two
Yeah,
days.
I went in at night and then I got out in the morning,
Right,
as I seen the JP judge.
yeah, okay. Could you check? Because that would be 2 days credit. And the reason why I'm asking the question is because every day that you stay in jail, you get credit of $100 per day. And in here, it would be $100 credit. But if you had 2 days, that's $200 credit. You don't have a fine. Let me see, but you have court costs. And the court cost is about what? 277? So if you had 2 days credit, instead of paying 277, you would only have a balance of 77. You understand what I'm saying? In the previous scenario, with 1 day credit, you would have a balance of $177. Okay?
It's April 7/6/25, release 7/6/25.
Oh, so it's 1 day? Wow. Okay. So she must have, even if she went in that night, they probably didn't book her into the next day. Okay, I understand. Okay. Now, let me do this here. Miss Hampton. The state, okay, in this case, is offering zero fine and that you sentenced to 1 day in jail and there's court costs of $277. You get the 1 day credit, so it's a balance of $177. Are you able to pay that? Or if you're not,
I would have been able to pay it earlier, but they closed my account.
okay, well, okay,
Yeah, they just texted me and saying they need more information, so I gotta go to Chase.
okay. So I just need to know if you're not able, well, she would have to fill out the affidavit thing.
I can pay it Friday, I could call up and pay it Friday.
That's cool. That's good. Now, okay, we can do that. So we could always give her until you say Friday. Okay. All right. Now, do you understand the state's offer? And do you accept the state's offer? Okay, Miss Hampton. I'll follow the plea bargaining agreement that you have entered into with the state. Miss Hampton, you're going to have a seat in that chair. And she guys, I think they have to redo the paperwork. Or do you already have the paperwork?
No,
Okay, and wait for your name to be called. And you have a blessed day.
thank you.
This will this will conclude the calling the court's arraignment docket on today's date of January 13, 2026, in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused. Y'all have a blessed day.